Good afternoon where I am, and probably evening where you are, or morning somewhere, depending on where you are. Not legal advice. This is purely opinion only. Don't rely upon anything I say, of course. I say that for obvious reasons. I wanted to bring you up to date on some news with regard to GTII. Tonight will be very short, very brief. And then tomorrow, as I will explain, it might be a little more in depth. Thinking about doing a live stream tomorrow at noon. So you could put that in noon Eastern. Before I tell you why I wanted to do a live stream tonight, 3 jokes. Of course, we have to do jokes, right? Did you hear? And I'm going to use pigs as the background for tonight's jokes, because sometimes I believe that maybe greed, piggishness gets people in bad situations. And I think maybe with regard to GTII, that also reared its head. So let's hear about pig jokes. Did you hear about the piglets who wanted to make their Mother's Day really special? They threw a sow prize party. What do you call a laundromat for pigs? Hogwash. And last but not least, what do you call a pig thief? A hamburglar. All right. So just to kind of give you a sequence of events. So today at 3 o'clock Pacific time, which is about 90 minutes ago, I had a meet and confer conference with the other attorney in my case, where I got sued for defamation. If you recall, I got sued because I called out management of GTII and claimed they were, didn't do their job, et cetera, et cetera. It speaks for itself. They sued me for defamation. So I have a response due in that case September 10th, I believe. So but it's required, it's in federal court. So as a result, before I can file my response, if I'm going to file a certain response, and I'm going to talk really slow so more people can get on and watch when I get to the more meaty part of this. But the rules in federal court, and some state courts too, I know this must be scintillating, are you have to meet and confer, which means you have to get on the phone or Zoom or in person with the other side, and you have to basically discuss what you're going to do and the basis. So we scheduled that. It happened at 3. I'd say lasted for about 15 minutes to 3:15. The other attorney who I've mentioned before brought his junior with him. I have an attorney also on the side, and he was there. He didn't say anything, but he was there also. We discussed various issues about why I found their pleading defective, and we concluded. I told him what I was going to do or what I was contemplating to do, motion dismiss, etc., as I'm required to do. Now, earlier in the day, before 3, and this is not the first time I've done this, I sent an email to the attorneys handling our case in Nevada, who I'm working with. And I again asked them to inquire about the status of the order in the receivership and TRO request. If you recall, in Nevada, 200 plus shareholders have moved to get a receiver appointed, to get a TRO, etc. And that was been pending. Even though it was dealt on an expedited fashion, it's been 2 weeks or over 2 weeks, and we were getting a little itchy about the order. Now the judge was busy, etc. So, but I asked. He said sometime later, probably around. So this would be about 3:40. I'm estimating now. 3:30 Pacific time, 6:30 Eastern. He sent me a email back in response saying that they had sent out a inquiry, I guess on Friday, or spoke to the clerk on Friday, and she indicated that an order would come out early this week, but it hadn't as of the time he sent the email to me about 3:30. And then about 3:40 today, which would have been about 6:40 Eastern time, so less than an hour ago. Yeah, less than an hour ago. I got an email from the attorney, and we got the order from the court. So the court has now ruled on the matter uh, brought by one of the plaintiffs' name is White Rocks to the first name, and then there's like 250 other names, including myself, against Reichman, et cetera, the various defendants. And I'm going to go through the order very specifically tomorrow, but for today's purposes, just so we know the outcome and where it's going. So we had requested a receiver and a temporary restraining order. And let me give you the ruling of the court as to that. So the ruling of the court is, consequently, the court grants plaintiff's ex parte motion to appoint receiver and issue a temporary restraining order on shortening time. So the court has granted our motion to have a receiver appointed to take over the operations of GTII. I think that's great news for everybody. There is going to be some steps from here to when there's a final order, and I'll talk about that tomorrow. But it certainly is a great first step, and the court really did kind of get it. And I'll give you a quick little blurb from the court that will kind of put this in context, and I'll be more specific tomorrow when we kind of go through it. But it pretty much, at least the way I read it, it pretty much reamed management. And not only did it ream management, but it stops management and considers them disqualified from being any current managers from serving as a receiver. We know who the current managers are, so I thought that was an interesting point. But basically, the court found three things, and we'll get into detail as to what supports it. The court found that plaintiffs, which is all the named plaintiffs and everybody here, and by the way, I really I find this really special, that because retail shareholders don't often get to participate in something. Usually they are the ones who are subjected to it. In this case, it's really a group of retail shareholders using excellent counsel outside, and hopefully I aided them too. But it's really a group of shareholders getting together and actually getting something. And to everybody out there who's been struggling on whatever ticker that they've been struggling on, it's nice finally to have a judge get it. And so quickly, and I'm just going to do this quickly, and tomorrow at noon, I'm going to go over the specifics. And if people have questions tomorrow, I'll try to answer them. But the court found that plaintiffs, being all of us, will likely prevail on their claims against global GTII, current management, defendants David Reichman, Kathy Griffin, Frank Benintendo, Donald Gilbert, and finds that they grossly mismanaged the company. That's one prong, and there's a bunch of items, and tomorrow I'm going to read those items to you, because it's, I think, my opinion, it's a ream job of management. Secondarily, the court finds plaintiffs and other shareholders will suffer immediate, severe, and irreparable harm unless management's enjoined from issuing shares, further fraudulent disclosures, etc. And third, the court found that in the balancing of hardships, because they're always balancing the remedy versus what the hardship is, the court found in favor of plaintiffs, us shareholders, in ordering the receiver and the injunction. So there's more to that than is here, but the bottom line is the court has ordered a receiver and an injunction against management. And, again, I don't think it happens very often, and it might be again, a way for shareholders in the future in particular states, if they're if they it's recognized as a remedy in a state, then maybe people should take advantage of it. For example, just so quickly over here, if you recall, or maybe you don't recall, in Nevada you had to have 10% shareholders to move forward. But that was the standard to get a receiver. But there were alternative statutes that courts could use. And one of them is if they were something on the order of, and this is not exact language, but something on the order, if it's a type of matter in which the courts have previously issued a receivership, then they can issue a receivership. And one of the bases the court relied upon in making its order is that. So now, if let's say I was in Nevada and I was trying to go after another company that I found their management to either be incompetent or whatever, I could cite this case as a case in which the courts have issued a receivership. And it might, open the door for other groups of shareholders to move forward. I haven't really thought of it in depth. It may be nonsense, by the way, but it just occurred to me because the statute says in other cases in which the courts have issued a receivership. Now they have in this particular case, and so maybe future courts might be able to rely upon it. Obviously, there could be further litigation on this, but the findings of fact by the court are pretty devastating, honestly, but logical. So tomorrow 12 Eastern, 9 Pacific, I'll do another live stream. If you have questions, get your questions ready, and I'll try to look to my right. JR might be with me to kind of go over this, and we'll go over the order, what it specifically says, what will happen from here, and where we are. But the result, I couldn't be more pleased than the result. I congratulated the attorney we've been working with. I think they did obviously they did a really good job. And again, for everybody out there, it's really nice to have something positive go on for retail shareholders or anybody on the retail side, because it just doesn't, unfortunately, doesn't happen that often, and it's not that frequent where there can be so many participants, named people. It really is a pleasure. Anyway, so I just wanted to pass on the good news. I will keep you apprised of any changes or whatever. Of course, like I said, there'll be litigation further, but I will see you guys at noon tomorrow, and we will discuss the order in detail and what's going to happen in the future. Everybody out there, be well, take care, and have a great evening.